All right, Mr. Escobar, your motion, you wish to begin?
I do, Your Honor. Your Honor, it's my understanding that this motion by the government was prepared by Mr. Martin, not Mr. Garcia. He just signed it, so I'll be addressing my arguments in reference to Mr. Martin if the court is pleased. Judge, as the court knows, we filed a brand new motion to dismiss based upon the new stand your ground immunity statute. I'd like to take the court a little bit about how we get to where we're at right now. This case is set for trial, and the districts, various districts have ruled on the retroactivity of the immunity statute. But I'd like to, first talk about how we get here. Obviously, we're asking this court two things. Number one, for this court to consider setting a new stand your ground immunity hearing for Mr. Reeves. We would like that hearing to be held on the date that the trial is currently set, meaning that we want the stand your ground hearing before the trial. Number two, and this is what I think is the more reasonable request, would be that the court stay these proceedings. I believe there are 7 pending cases right now that are awaiting a Florida Supreme Court decision on retroactivity. All those cases have been stayed by the Florida Supreme Court. And so I think the more prudent thing to do is to stay these proceedings until the Supreme Court decides on retroactivity. But I'd like to initially take us to where we're at and why. As the court recalls, this case was set for trial at a status hearing. I was not at this status hearing, and to be honest with you, and it's probably my mistake, Your Honor, I had no idea that it would be set on the date that we had that status hearing. But it was set on that date and arguments were made. And I'd like to focus on those arguments because I think that's the reason this case was set for trial. Mr. Martin argued on that particular day the Martin decision, which is the second district, what I believe to be the controlling case for this court from the Second District Court of Appeal. Let me read to you what Mr. Martin said when he was arguing this case before Your Honor. Mr. Martin, in explaining the Martin decision, said to this court, and you know what? It's unique about it, meaning the case, is they did not vacate the trial decision. That's what he said. They kind of set up a procedure. He talked about if you go by the second district logic, you set the trial, you get it over with, and if the Florida Supreme Court comes back and says it's retroactive, then the trial's done. And I think his argument was leading the court in that direction. But before we get to the court's response in reference to that issue, what's important for us to all know is that the Martin decision, in its very opinion, says we are vacating the jury's verdict. And I'm going to direct you to that if I can. If you look at your tab number 3, which is the Martin decision, if you go to the very last page of the Martin decision, it's page 6 of the Martin decision. Let me know when you're at page 6 is at the very bottom right-hand corner of that.
Okay.
And if you go to the paragraph right above the number 4, I'm going to read this to the court. This is the court making this ruling. We are confident that the circuit judge who presides over Mr. Martin's immunity hearing on remand will not rely on the prior jury's determination that we are vacating. But will convene a new evidentiary hearing in an appropriate fashion, consistent with this court's opinion and the statute amended burden of proof. There is absolutely no doubt that the Martin decision just like every other district decision that's held on the retroactivity, has vacated that decision. Now, as the court well knows, the court's obligation in looking at a statute is not to change that statute in any way, but it's to interpret that statute. The court does not sit as a legislator. That's for the senators and representatives up in Tallahassee. It is there merely to take a look at the legislative intent of that statute and carry that intent forward. But in Mr. Martin's argument, and I think he was persuasive to the court, I think that this court adopted his statement that somehow the second district had not vacated the jury's findings. They had. Because let me tell you what the court says. The court, after he's making his arguments, and this is part of the transcript, Your Honor, that's filed with the court. The court says, had the second determined that he's entitled to a new immunity hearing and vacate the conviction, the sentence, or the conviction, sure, I wouldn't be setting this. I wouldn't be thinking about setting this for trial. So clearly at that moment, the court accepted Mr. Martin's interpretation of Martin.
Now, hang on just a minute. While we're on that issue, I don't mean to interrupt, but I don't want to lose track because I know you're going to continue and then I'll have to come back. And I just want to address that issue right now. In the Martin decision, the court goes on to, I think they were aiming the vacation at the jury's findings that obviously they rejected a self-defense assertion and all of the otherwise determinations that they would be making, that they found him guilty. So that would be clearly, if you're going to have a new stand your ground hearing, the court could not take that into consideration. That's what they're saying in Martin, not to consider the jury's verdict. But at the end, if immunity is not granted, then the defendant's sentence is reinstated, verdict, and there's no new trial.
Well, I agree with that.
Okay.
But in order to have a reinstatement, you have to have a vacating of the actual jury decision. And so what I wanted to make clear here is that I really do think that at that point in time, at least from what I read from the transcripts, I was not here. Remember, it was Mr. Michaels that was here during that argument and did a fabulous job in arguing as best as he could under the circumstances not to set a trial. But it is pretty clear that in the court's discussions with Mr. Michaels and Mr. Martin, that the court clearly said, look, had this been vacated, maybe I wouldn't be setting this matter for trial. What's important for us to take a look at in the intent of the statute, which is clear. In the statute, it says, it doesn't say post-trial immunity hearing. It doesn't say immunity hearing whenever the court wants to set it. The statute and the legislative intent is crystal clear. It says pre-trial immunity hearing. And so that's the legislative intent. That is the intent that this court should follow and should adopt in setting such a hearing. It's not only the statute. The Martin decision says that these hearings should be held pre-trial. And even more important, a case that's not even connected in any way, shape, or form with reference to these retroactive appeals. And that is the Florida Supreme Court case in Denison. The Florida Supreme Court case in Denison is crystal clear. Let me read to you what the Florida Supreme Court says about how we're supposed to have a pretrial immunity hearing. It says Section 776.032 contemplates that a defendant who establishes entitlement to the statutory immunity will not, and I repeat, will not be subjected to a trial. If you look at the legislative history of this stand your ground hearing, that was the whole purpose. They wanted to enact a statute so that individuals would not have to go through it financially or through the very cumbersome process of getting prepared for a major trial and try a case. That's the whole purpose of the immunity statute. What Mr. Martin did was he disregarded the statutory intent. He misinterpreted, and I don't think by any stretch of the imagination he was doing it intentionally, but he misinterpreted the Martin decision, and he came up and became a legislator and said, well, listen, we can do something different here. Let's just have the trial first, and then after we have the trial, we can have the stand your ground hearing. Of course, if we lose. The doctrine of stare decisis, Your Honor, is a doctrine that is very important, not only in this case, but in our entire system of criminal justice. And that doctrine, to make it in simplistic forms, is that if we have a District Court of Appeal or a Florida Supreme Court decision, and we have a like issue before this court is obligated and bound to follow that precedent. It is as simple as that, and they do that so that we could have some uniformity in the appellate process, so we could have some uniformity in the trial process. So it's really it's the foundation of our criminal justice system. It's what we use in order to guide what our clients should do. The issue that's been brought up by the government now is, what is binding? What precedent is binding on this court? And so we brought before the court a case by the name of Pitzer versus Bretty. And I've given it to the court with an opinion. I'm sure you've read it. But that court is very, very clear. That court says that a decision becomes binding, or having that stare decisis effect, when it is issued. In fact, that decision says that although opinions of the Second District carry a banner, the banner that we've got, although they carry a banner, not final until the time expires to file a rehearing motion, and if filed, determined, said banner does not mean that the issued opinion doesn't carry its effect. It's a Second District Court case, so the stare decisis obligation applies to this case as well. That's what guides us in making these interpretations. Now, does anyone here in this courtroom think that if a Martin decision was not valid precedent to be viewed under the doctrine of stare decisis, do we think that the Second District would be citing to Martin over and over again? Do we think that the First District would be citing to Martin in their opinions? Absolutely not. Because these are the appellate courts that understand that, hey, if a decision has been made and it either has persuasive or binding effect, we're apt to be able to cite it. Now, in Mr. Martin's response in dealing with this issue, what's binding? He takes the position, and he again assumes, that there is no difference in the appellate court's designation of an unpublished disposition versus an opinion that has not yet been released for publication. He just assumes that. You know, one of the first things that we did when we got that response, it was pretty easy to try to find case law that would refute that, because there is a pretty important treatise that we've all used in appellate work. It's by Judge Philip Padovano, who was a First District Court judge, now retired. I believe he's now in private practice. But he wrote, the book on appellate practice in Florida. And so when you look at Judge Padovano's segment of his treatise in reference to this issue, he clearly explains the reasons that there are different meanings. This is not an issue, Your Honor, that's been dealt strictly by the state courts. This is an issue that also has been dealt by the federal courts. But Judge Padovano, let me get you exactly what he says. He says the following. An appellate court may dispose of a case with a speaking order or a memorandum style opinion that is available on Westlaw but not published in the official reports. These kinds of decisions, and this is what's important, these kinds of decisions are usually written to explain the case to the parties. So it's a limited purpose of these types. And not to create a precedent for future cases. While there is no governing court rule on the subject, Florida courts have held that an unpublished disposition has no precedential value. So now let's take a look at what an unpublished decision is versus an opinion that has not yet been released for publication. Because it just so happened, I think it was just luck of the draw. It just so happened that Mr. Martin cited Gawker, so did Padovano. But when you take a look at Gawker, and Gawker is the famous Balea trial that we all have heard about. When you take a look at Gawker, every single case that was at issue in Gawker had the heading at the very top of the opinion. In our reply, we took the liberty, Your Honor, and I'm sure you got it, we highlighted in yellow what a unpublished disposition looks like versus what a opinion that has not been released for publication looks like. And let me not confuse you here. The appellate courts don't have these designations for the fun of it. They are true designations that have a meaning, and they're very strict with those particular designations. But what was, I think, a wonderful thing for this case is that on May the 29th of 2018, which was unfortunately the day that you decided to set this matter for trial, instead of setting it for a stand your ground hearing, the case of Aldrich versus the state of Florida was decided. I'm going to pass this up. Mr. Martin has it because he had it in his list. Can I approach, Your Honor?
I've got it. I've got it right here.
You got it. The case of Aldrich versus the state of Florida, which is located at 2018 Westlaw 3629436. And that case was an identical situation to the Reeves matter, because in Aldrich had not gone to trial. The court recalls in Martin, he had had a stand your ground hearing, he had lost. He had gone to trial, he had lost. He had been up on appeal, the law had changed, and the appellate court said, you know what? It's retroactive, so he gets a brand new stand your ground hearing. But in Aldrich, he had not gone to trial. He had had your stand your ground hearing and you had lost. And why did the court in this case file an unpublished disposition versus an opinion that has not been released for publication? It's the Padovano reasoning. That this was a case that did not need a lengthy opinion with an analysis. Why? Because they cite Martin as controlling precedent for their decision. And they say, hey, listen, we issued Martin, this is what controls, give him a new stand your ground immunity hearing, pre-trial. Now, if we were to accept Mr. Martin's argument, and remember, he made this argument about, let's do the trial first and the stand your ground hearing second. If that was true, if that was possible, if that was even contemplated by the Second District Court of Appeal or any court of appeal, On May the 29th of 2018, they would have told the Aldrich Court, hey, listen, he gets to stand your ground hearing. But you know what? Set it whenever you want to. If you want to have the trial first, you can have the trial first, and then you can have your stand your ground hearing. And the Aldrich Court didn't do that. Which shows, Your Honors, that we cannot legislate changes in these laws. They are what they are. If it's a pretrial immunity hearing, it's a pretrial immunity hearing. That is Aldrich. I attached specifically for the court to see every Gawker decision that was at issue. And you will see that every decision, every appellate decision that Gawker was dealing with, which were all unpublished dispositions, are attached, and you can see for yourself why the court made the rulings that they did. And that is in conjunction with Padovano. Now let's talk a little bit about the issue of staying the proceedings and why that is, in my opinion, and in the opinions of Mr. Michaels and Mr. Shaw, the most prudent position to take. I think we discussed at the last status hearing that we had with this court, just recently, about a month ago, that we have all these appellate decisions out there that have been stayed. The Florida Supreme Court has found that the appropriate remedy at this point in time for all of those cases is to stay those decisions while the Supreme Court is making the final decision as to retroactivity. Our position is that that's what we should do here. We should not be setting it for a new stand your ground hearing. We should not be setting it, obviously, for a trial. We should be waiting for the Supreme Court to give us their final determination on retroactivity, because we want to get this right. We don't want to get this wrong. If we were to have, for example, a stand your ground hearing in February, it would cost the defense about close to $100,000. And, Your Honor, I think I told you before, if that was possible and that would be res judicata for my client, I'd say, set it for February, we're ready to go. Because it would be worth that opportunity knowing that it would be res judicata. The problem with that is, if we set that particular stand your ground here, and let's assume that we win, and the Supreme Court comes back and says, sorry, it doesn't apply retroactively, we have lost $100,000 in costs. And a lot of effort of this court, and a lot of effort of defense attorneys, not only defense but prosecution as well. That is, in my opinion, a waste of judicial resources. That is a waste of our entire criminal justice system, including a battalion of witnesses that would have to come for little to no reason. The best alternative for us at this point in time, Your Honor, is to stay these proceedings. I will tell this court, I've been doing this for 35 years, justice doesn't have a time limit. Justice doesn't have a time limit. I can tell you, Catalano, it's a 2014 case. The case that the Florida Supreme Court stayed, which is Catalano, was a 2014 case, just like Mr. Reeves' case. But they found fit to say, we need to do this right. We need to have an orderly process in this whole endeavor. I truly believe that if we go forward with a trial and we are wrong, at 74 years old, I don't think my client will make it out of prison. I think we all owe it to an individual that at this point in time in our justice system is presumed innocent to wait for the decision of the Florida Supreme Court to give us the guidance that we need in order to do this right. So I'm asking the court today, respectfully, to stay the proceedings and to let's wait for that decision to be made. I can tell the court that we are not going to get a decision from the Florida Supreme Court by February of next year. The Supreme Court of Florida accepted jurisdiction on a case that myself and Mr. Michaels tried, which is the FAMU case, the Dante Martin case. They accepted, I believe, jurisdiction to hear our case in June, I believe it was June of 2017. We had oral arguments, and Rupa, correct me if I'm wrong, we had oral arguments in February of 2018. Here we are just about on the cusp of September, and we haven't heard a peep. So I seriously doubt that we are going to get a decision in this case before February, the date that the trial is set. And the problems with rolling the dice on those issues is to say, okay, Rick, we're going to set it for a stand your ground motion. The problem with that, we'll probably get a hearing before then, is that we're sending out massive subpoenas. We're getting witnesses lined up, experts to block off their calendar. It's a nightmare. And so, again, Your Honor, I would respectfully ask that you consider staying these proceedings and following the law as I see it under the doctrine of stare decisis in this case.
Thank you, Mr. Escobar. Mr. Martin?
Thank you, counsel. Judge, in State versus Curtis Reeves, Mr. Reeves had his pretrial immunity hearing pursuant to that. No question about that. He also exercised his right to appeal. He filed a writ of prohibition, and that was denied. And if you might remember the discussion that we had at the last hearing, there was an issue about whether or not the mandate had been filed and whether or not the court had jurisdiction in Reeves. And based on our review of everything, it was determined that in the Reeves case, this court has jurisdiction to set its calendar the way it sees fit. And that's what the court did in this particular case. At the last hearing, we had the similar arguments. And the state also argued that because a mandate in Martin and in Love, which is conflict, had not been issued, the Florida Supreme Court has in fact issued its stay. And now the Second District has continued to handle the cases as it sees fit. It's going to continue to issue its opinions as it sees fit. And all those cases are going to get in line behind Martin. All those cases will get behind Love, and they'll all go up together. The Florida Supreme Court, and all but one, I believe, I think it's Sullivan, has issued its stay of the mandate. So in those particular courts, they're at limbo. But here, in this court, once the writ of prohibition has been denied and the time for rehearing has passed, this court has jurisdiction. You heard the arguments of counsel at the time, and you set it for a trial based on the arguments at that time. Now, at that previous hearing, there was discussion regarding the Martin case and the Love case. But the bottom line is, Judge, unpublished opinions. Whether they're tabled or not, unpublished is unpublished. An elephant is an elephant, unpublished is unpublished. So if it's unpublished under Gawker, there is no precedent. And why? Because it's not final. It's not final until a mandate is issued and it is published, or the Florida Supreme Court overrules it. It's not final, so there is no precedent, and that's what Gawker is all about. Now, it's interesting that Mr. Escobar wants to cite Pritchard, but if you look at that case, what did that case deal with? It dealt with at what point in time, when does the time period start to file an appeal? We're talking apples and oranges here as far as whether or not Pritchard actually applied. It's interesting to know he didn't bring up Wood today, but he argued that extensively before. But Wood is equally distinguishable in this particular case, because in the Wood case that's cited by the defense, that dealt with other cases that were in fact published. So the Wood case is distinguishable. Pritchard is distinguishable. What we have here is we have these cases that are in fact unpublished. If you look at the heading of the cases, the only site available is the Westlaw site. So I think I have very succinctly, in my reply to his motion, set out the state's position that this court right now has jurisdiction because the writ of prohibition has been denied. You have set it for trial. That's what you have an absolute right to do. There is no precedent as far as Love and Martin because they have been certified to the Florida Supreme Court as being in conflict. All these cases are getting behind that. If you look at Aldrich, and Aldrich is the anomaly because the Attorney General, for whatever reason, conceded error, and the court had no other recourse but to accept the concession of error. And they didn't say, we are relying on Martin. They're saying, based on the concession of error, you can go back and have a new hearing in accordance with Martin. So they didn't rule, really. They just accepted the Attorney General's position. And it is, in fact, again, another unpublished opinion, so that it's not precedent to this court either, that they relied on Martin. Therefore, if you buy Mr. Escobar's argument, it's not a precedent that this court should, in fact, follow. Judge, here we have the Florida Supreme Court has issued stays of all the mandates. The cases that are deciding the retroactivity of the new statute have been found in conflict and certified to the Florida Supreme Court. They're awaiting the order from the court. But right now, this court can see, if it sees fit, can set it for trial, which it did. So based on the memorandum and the argument that I made in my response, which is very succinct and to the point, I rely on it. This court can do what it will with its calendar. You've chosen to set it for trial. The state's position, it needs to be held on the trial calendar. We'll be ready to go February 25th. If the Florida Supreme Court decides it's retroactive before then we'll deal with that issue once we get that final ruling. But the state's position that this court has absolute authority to leave the trial for February 25th of next year, and that's what the state is asking this court to do.
Thank you, Mr. Martin.
Your Honor, I just would like to correct one thing, and I'm sure it's just an error on Mr. Martin's part. He indicated that in the Aldrich decision, the state had conceded error. It's not the Aldrich decision that conceded error. It was the commander decision that conceded error. And it's in his own memo. So I can show you where it's...
Yeah, I misspoke, Judge.
Okay, I remember reading both of them, so... All right, thank you, Mr. Escobar. In follow-up to Mr. Martin's contention that I am absolutely within normal reason to control my calendar as I see fit, and that's kind of what I indicated at the last hearing. I've been frustrated with the length of time this case is taking, and there's been a lot of things that have been completely out of everyone's control, so I'm not pointing fingers at anybody for the length of time, age of this case. And by the way, Mr. Escobar, two wrongs don't make a right. Just because I've got a bunch of old cases out there, or not a bunch, but a few others that you pointed out, that doesn't mean this one has to continue to be old. So it boils down to, can I, should I? I've given this issue, all of the issues in this case, a great deal of thought, as I do with each and every one of the cases on my docket, some more than others, obviously. This case will expend an extraordinary amount of resources on every party involved. The taxpayer's primary primarily is who I'm considering. Obviously, the state representing the taxpayers and spending taxpayers' money. But the defense will bear a tremendous cost as well. And 3 weeks out of my calendar is an astronomical amount of time when it comes to, can I afford to let that go by the wayside? I can't risk losing that time. I have to agree that this case just isn't ripe for trial. I need a date that I know we're going to have, that everything's going to be settled, and Mr. Escobar is absolutely right in all of his arguments that I could keep it on for trial, but in so doing, I would also run the risk of, in my humble opinion, running afoul of the second DCA opinion. I understand Mr. Martin's arguments about that entirely, but I also am well aware that the second has issued other opinions with the same holding as the Timothy Martin case. That to me says they think it's kind of precedent. And if I'm going to make a major decision, such as getting this case set for trial and expend a significant amount of resources, I want to know that I'm on the right side of where I should be. I don't want to have any gray area. I don't want to have any concern that maybe I'm not acting properly. The second's given me a pretty good idea in the Martin case of how they feel on this issue. We are in the second under the second DCA, whether it's unpublished or whatever the status is. I understand the argument, and that I just don't want to be looking at the second after we do a trial and having them come back and say, what were you thinking? What were you thinking? We thought we made it pretty clear what you're supposed to be doing in these things. And I'm well aware, Mr. Escobar, of course, you argued at length about the pretrial status of these hearings. I know it's supposed to be pretrial. So for all of those reasons, I'm going to remove this from the trial calendar. And as much as I would like to see it progress, I think I'd rather have multiple root canals than go through another hearing if I don't have to, a stand your ground hearing of that length. It came out that it was only 10 days long. Is that all it was?
It was 10 days, working days.
It seemed like much longer to me.
To us as well.
So I would really not want to have a repeat of that. That was a very intense, lots of information coming. It was a lot of work. And I'd rather not do that unnecessarily, because that's the second option. We could hold that hearing on February 25th. But again, I don't know what the Supremes are going to do. We've got all these cases lining up on both sides, and I don't know. And with that just hanging out there, and the amount of resources we'd have to expend for another stand your ground hearing, and I'd have to commit to 3 weeks of this court's time, maybe for naught, as you indicated, Mr. Escobar. I'm not really willing to do that. If this was a 3-hour stand your ground, I would absolutely set it and we'd hear it and get it back on the trial calendar. It's not, that's not the case here. So the only viable course of action that I can see in this case is to stay the proceedings. So that's what, as much as I don't want to do that, and as that's my decision. I'm just going to keep my fingers crossed that the Supremes hear this fairly quickly, with all the cases stacking up to be heard. I have a feeling they will give it some priority, I hope. So hopefully we'll get a decision sooner rather than later, and we'll get it back and proceed accordingly.
Thank you, Your Honor.
Thank you, Mr. Escobar. Thank you, everyone.
Court is in recess.
Yep. Thank you.